Howdy, and welcome to the White Hat Law Show with Warren Nord, where we cover a mix of current events, politics, and the law. Take it away, Warren.
Hello, I'm Warren Nord. I'm owner of Nord Law. And today, I appreciate you joining us. We're going to talk about patents and all things prosecution. If it has to do anything with patents, we're going to talk about that today. And joining us, we have a seasoned businessman here in Tarrant County, Al McAuliffe. Thanks for joining us, Al. Some people who are watching may not know who you are. So tell them just a smattering of who you are.
I would think it'd be most people that really don't know who I am. I started out in the manufacturing business and manufacturing rubber products, and that was kind of the money and the foundation for a lot of other businesses that we're involved in today. We're in oil and gas. We were in aircraft leasing, restaurants. We're out of restaurants, which many people might know in Tarrant County. And I just made an acquisition a year ago of a cigar company with very old technology. And in the cigar business, old technology is good.
Right.
With folks that were all from Cuba, and they've got a lot of the old techniques. So I'm having fun building that company now.
Well, that seems like a lot of fun. Once you get it's that first part. Once you get going, you can start to adventure. Well, tell us about your experience with patents. What was your first patent experience like?
I think my first patent was probably 40 years ago. One of our product lines was gasketing for stoves. And we developed, and they were very tough to install because they had all these clips and stuff that needed to be pushed in to hold the gasket in place. And I developed a stretch gasket, which stretched and it popped in place, and it reduced the assembly time by 31 minutes. So it was probably today, even though with the number of patents I have, probably one of the more successful patents that I've had because it served an entire industry.
Right. Now, of course, we'll get into the details of what patents look like. Were these all U.S. patents?
I was just about to tell you, as naive as I was, they were U.S. patents.
Right.
And then I got an idea that I needed to do something overseas. So I was over there, I was in England, and I bought a manufacturing plant in England, but I never patented the process for these gaskets. And they have the same kinds of issues there with their ranges or stoves or whatever you want to call them. But my competitors copied our stretch gasket,
right.
And we shared in the industry, but not like we did in the U.S. because we virtually had about 95% of the U.S. market with the patent.
It's often and again, we'll get the details of what an international patent, as we refer to it, looks like, but it's a big issue. You can get a patent here in the United States, and it protects you very well, but then if it's, say, it's coffee or something that's actually dominate more manufactured more in other places, then that patent isn't near as valuable unless you also protect it in those other places. Now, of course, your first patent being some odd 40 years ago, were you able to file any continuation patents based on that?
Yeah, we continued to upgrade the application, but we did that more. It was a broad patent that dealt with the process and the design as well as the materials that were used. And as stoves or ranges got hotter and hotter, the glues that held these clips in place were challenged.
Right.
And so we kept upgrading and developing glues that had a higher temperature. So we were able to get continue that patent for a very long time by continuing to develop the technology. And the interesting thing about that is that, that was a single element in the patent that was obviously the most important. Because if those clips, no matter what you design, if those clips pulled out,
right.
the process, the gasket was useless.
Right. Okay, so you've done we talked about continuation patents, we talked about international or patents outside the country. People always ask the question, how much should I put budget for a patent? Give me an idea of what a start to finish patent in your experience
Yep.
has run?
Well, one of the advantages that the industry has today is when you have an idea and you're concerned, of somebody else understanding what you're doing, and you want to get a patent on it, you have the opportunity to get a provisional patent,
Right.
which gives you the protection while you sort through whether this is a really valid, really good idea.
Well,
Which
it doesn't give you protection, right? It gives you priority for if you file a patent in the next year. Of course, it doesn't give protection until you get the patent.
exactly.
But it establishes that priority. And that
Yeah,
can be important,
in
right?
case somebody decides to
Right.
jump into the same pool with you,
Right.
you've already established that this was your
Right.
idea initially.
You were here first.
Yeah, well, you were here first, yeah. And so then at least you have some time to evaluate what you're doing. And, a lot of times you have great ideas, but a lot of other people have the same great ideas, and you've got to do that research,
Right.
And when you start poking around, then you're exposing yourself to other people knowing what you're doing, especially if you're a leader in your industry. Everybody's watching what you're doing.
Yeah, it's funny. Intel doesn't even bother sometimes with some of its patents. It'll just file a disclosure to let everybody know what they're doing, because nobody else can do what they're doing, right? They just don't want somebody else claiming that they did it first.
Exactly.
So if you're the industry leader and you can do things that nobody else can do, you have a distinct advantage. Have you ever litigated any of your patents or filed infringement?
Yeah, we
claims?
have. We have.
Tell us about that a little bit.
First thing you need to do is make sure you're on real solid footing.
Right.
And your patent attorney certainly is a guy that can help you with that process. It's an expensive proposition, and it gets more expensive every day. But normally, most companies or individuals that are involved with, say, possibly violating your patent or infringing is probably the better word, infringing on your patent, nobody wants to, the liability side of that can be so large that you could probably either settle or license someone,
Right.
or you could scare them away. Yeah, so sometimes you don't have to go through that long, lengthy process unless you're Google or Apple or whoever.
It is amazing how much money these guys spend on it, and you look at what they're doing, and really, but it's right. So you have to enforce a patent in order for it to be useful. Really.
Yes.
And so it can be an issue. Last thing I'd ask you for is, what advice would you give to somebody who's just starting out and they've got a beginning of an invention and they're looking at patenting process or protecting their invention?
Well, my advice would be, find a patent attorney that you're compatible with, that you can talk with, that's open, and then look at your invention and try to determine whether or not, if you were trying to beat that patent by a competitor or whatever, what could you do to get around that patent?
Right.
And then when you're doing your patent application, make sure you fill all those holes.
Yeah, it's just like whatever. If you're putting security together for a bank, pretend you're the criminal, and how are you going to break in? You got to set up that security
Yes, sir.
to start
That's a
that.
perfect example.
So yeah. Well, Al, I appreciate you coming on, taking the time to come and visit with us today.
I was delighted to be here. It was fun.
When we come back, we're going to talk about kind of the basics of Patents 101, and then we'll talk to a potential inventor who thinks he's maybe have an invention that he needs to have patented. So we'll be right back.
Hang on, y'all. More with Warren when we get back. Welcome back, folks. You're listening to the White Hat Law Show with Warren Norrid. Take it away, Warren.
Welcome back. I'm Warren Norrid, and I want to thank everybody for coming back. If you were here earlier, you saw Al McAuliffe, and he was helping us with his experiences on patents and how those had worked. And before we get on with another inventor, I thought we'd sit down for just a second and talk about how patents work and some of the things that you'll hear when we talk about patents. Patents are provided for in the Constitution. It's actually something to talk about protecting the arts and sciences, promoting that. And so we talk about the arts, the prior art of a patent. And so the patent law is written to say that an inventor gets a patent unless. And so if you're looking to get a patent for your invention, you can have inventions without a patent, But like this cool pen has a front end, but it's not patented, but it can be used as a stylus. So not every invention has to be patented. But if you want to patent your invention, there are some things that you have to make sure you do. And we refer to these just by the section of the law that come into play. And it's 35 U.S.C. 101, in case you want to look it up. It's any, and I'll just read this. Whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof, may obtain a patent, therefore, subject to conditions and requirements of this title. So the 101 we also refer to as kind of the law of nature. If it's a law of nature, it has to be something that you invented, not something you discovered. So you discover pi, you don't get to keep that to yourself. And then there's the 102, something that's been done. If it's been done anywhere else in the world and disclosed last week, it's too bad, you don't get a patent. If it's not novel and obvious. And this is where patent attorneys often make their money. If something's never been done, and I always use a windshield wiper on a fairing of a motorcycle. I've never seen one, but it could be done. Would that be patentable? Well, we have fairings, we have windshield wipers. Probably not, unless you did something novel with that that's not, it'd be kind of surprising. So just because something's never been done doesn't mean you can get a patent for it. Although it is certainly the first start. And then lastly, not enabled. You come to me and you say, Warren, I've got this great idea for a small flashlight-looking item, but it extends out about 3 feet with light, and it cuts through the walls, and you can fight with it, like a Jedi, of course, lightsaber. And I say, how do you build that? And you say, I'm still working on the details. Not enabled. So you don't get an invention for ideas. You only get you don't get a patent for ideas. You only get a patent for actual inventions. So people talk about provisional patents and non-provisional patents. A provisional patent application, it's not a patent, it's a patent application. A provisional patent application is one where you say, I've got this, I'm still working on it a little bit, I've got the details for it, at least to some degree, and you file this provisional patent application, and it kind of holds your place in line for a year. Now, it's not examined, you don't have protection, but you hold your place in line, so if somebody else invents something later and files for the patent, you'll still win. These come and go, and you can talk to different attorneys about their approaches on that, but typically it's better to go ahead and go with a non-provisional. Most provisionals that are done by people who are not attorneys don't make the grade, because you have to have everything disclosed in your provisional, or you can't use it for your non-provisional, and that's the one that you want that's going to give you the protection, a non-provisional patent. And so that's non-provisional versus provisional. And then there are different types of patents. Usually when we're talking about a patent, we're talking about a utility patent. That's what I just described. Okay, say it's an apparatus or process. But there are also plant patents. Aunt May's new rose bush is a strange thing. And so you can get a plant patent, and you can get design patents. Lamps are known in the world, but you might have a novel lamp that has a structure, or my handy cup. I might have a design patent on that, or an expensive purse might have a design patent. It's not that the purse is novel, but the appearance is novel. And so that's what you'll find with a design patent. And they all last a little bit different. Typically, an apparatus patent is 20 years, and a plant patent is 20 years, but a design patent is only 15. Now, of course, we're only talking about, typically when we hear people talk about patents, they're usually talking about the process in the United States. There is something called a PCT, Patent Cooperation Treaty, with a lot of countries that we do business with. And that's not an international patent, but it's a process to lower the cost, because it costs so much money to have a patent and cover any number of countries. So when you hear the PCT process, that's a process by which you can save some money and you go out to different countries. Most I've ever done was 54 countries on one patent application, and it was a nightmare. Well worth it if you have a patent that needs protection. And quite often these days you do, because things are built so often in other places. Some things you ought to know about patent searches. If you don't start with a patent search, you may be wasting your money. Patent search goes out and says, well, these are the things that are standing in my way. Maybe I can make a little change and I can get past that patent. So it's important to do that. And then there's a freedom to operate letter. You'll hear that phrase. Freedom to operate letter says, I'm going to make sure that even though I'm not getting a patent on this handy little device, there's no patent that's in my way where I'm going to get sued for developing and selling this product. So those are both very important parts, and a good patent agent will try to do both of those for you because you don't want to be sued. Now, when you're picking out a patent or a patent attorney, you want to make sure that somebody that knows something about the subject matter that you're dealing with. It's good to have been involved in some litigation, because if you don't do that, then it's easy to get a patent that can easily be overturned or canceled, or when you go to sue somebody for infringement, then they're going to be able to knock your patent out completely. So it's helpful to have at least some litigation experience. There's a lot of in every patent consultation I do, eventually somebody says, Warren, you've been doing this a long time. Can you get a patent for me on this or not? And the answer is, I don't know. I've done patent work for people where I thought this is going to be, I don't know how we're going to make this happen, and it goes through. And I've also done patent applications where I thought, well, this is going to be a good one, and we don't get it through. I won't say it's totally arbitrary, but I'll say that it depends a lot on the details of what's out there, and it's hard to know that until we actually get into it sometimes. So that's the long and the short of it. It's mostly the short of it. It's important to actually visit with 2 or 3 patent attorneys and find one that you're happy with. And they don't have to be local. You can do work for people anywhere. I do work for people all over the world. So in a minute, we're going to come back. We're going to talk to a real live inventor, and we're going to kind of go through some of these things and what we think about that. So we hope you'll join us then. Thanks.
Hang on, y'all. More with Warren when we get back. Welcome back, folks. You're listening to the White Hat Law Show with Warren Norrid. Take it away, Warren.
Welcome back, and thanks for joining us again. We're talking now to a real live inventor, and he and I have not spoken before a few minutes ago, so this will be fun. Chuck Hawkins, a craftsman and inventor. Chuck, tell us a little bit about yourself and what you have today.
Well, I just like making things, and today I'm looking at getting a specific knife design of mine patented.
And what? Of course, this is public, so I guess we have to be careful at what we're saying. But tell me, have you actually created this knife?
I have designed the knife and done some prototypes, but not in full function. So
Okay.
I've not crafted it out of metal yet.
Okay,
Not the final product.
but you could describe it well enough. What we have to do for a patent application is that we have to describe it well enough that another person that's a practitioner in the art, another knife maker, could look at your drawings and the specification that you've provided and say, I can make that, just the way he's described it. So have you reached it to that point?
Absolutely.
Okay, so that would be, now would you say it's novel because it's a different kind of what? Is it a different kind of locking mechanism, or is it, what makes it different?
This is a fixed blade design. It's something that is a multi-use tool meant to take the place of a lot of different other tools. You wouldn't have to carry as much in the woods.
Okay, so so it's an apparatus, and it's a multi-use tool, a multiple tool apparatus. And so when we talk about an item like that, there's usually 2 or 3 things that come into play. Has it been done before? Have you done any searching on this?
I have, and there's not anything I can find that's exactly the same.
Okay.
That's what I've done.
If there's something that's, I don't know if you heard me earlier, but if we talk about the 4 laws that we typically have to deal with, there's in this situation it's either a 102 or a 103 situation. So a 102 rule, the law 102, section 102 says if it's been done, then you can't get the patent, right? And 103 has to be novel and inobvious. So, for example, and I'll just use this as an example, there's a lot of screwdrivers, right, that have where you can unclick the Phillips and put in the standard, or the Empire, whatever we call it these days. And so if you want to get a patent on something like that, you have to show that you're doing something in a way that's never been done. If you are combining tools into a particular kind of apparatus, then you have to show that it flows in a different way than somebody might guess. And so that's kind of the 103 scenario, is whenever I'm dealing with something of that nature where it's a combination of different existing things, then that's a 103. So I have to show the patent office. And typically, what we do is we'd put together a specification, some drawings, and some claims. And the claims might have independent claims and dependent claims. You have up to 20 claims. And so, and the claim might be a knife with an edged blade on one end, on one side. And I'm just making this up as I go, right? And so,
Sure.
and then the claim 2 might be a knife as described in claim 1 that has a handle that folds out into a cot to sleep in, something crazy, But the first claim is independent because it doesn't depend on anything else. And the second claim would be a dependent claim, and it describes further that knife. And so you'd have up to 20 of those, and we would provide the drawings so that the patent office could say, this is what we're trying to do. Now, the patent office is kind of like a large insurance company. You send a big bill to them to pay for something, they're quite often going to say, I'm sorry, we don't handle your broken bones. And you have to respond to that refusal. So we would get an office action, and that office action would be usually a year and a half, 2 years, sometimes 3 years. But in something like this, a basic mechanical design, probably right around 2 years. So we'd file it. The filing fee would be either $400 or $800 typically. The way it works is, and this is as of a few years ago, right now it's a little over $160,000. If you made last year, then the filing fee is $400. If you made more than that, then it's $800. Or if you have somebody else that owns a piece of it, it can be more than that. But and the filing and the attorney's fee is going to be somewhere between $2,000 and $3,000, give or take, to do a simple mechanical design. Assuming that there's not a strange ruby that's grown on the dark side of the moon that powers this thing, right? Normal mechanical patent, you can expect to spend for the initial application process, $3,000 to $4,000. And this is as of today in 2018. Things change, right? So we go into the long wait, then we eventually come back and it says that you don't get a patent, and we have to respond to that. And so then we respond to that and we say, well, this is why you can't just combine these 3 items and say that it's obvious. And we would talk about why that is. And then they might look at that and say, we accept your idea, your argument, and they either give you a notice of allowance, or they say, if you will make these changes to these claims, then we'll give you a notice of allowance. If you get a notice of allowance or subject matter that's been allowed, then you dance a jig, you clean it up, and you take the win. That's the one route. The other route is you get a final rejection. And usually this is about 2 to 4 years into it. And if you get a final rejection, but you were close, then you file a request for continued examination, which takes you back to the point where you have 2 more shots before the patent office. Or you say you abandon, and you say it was a fun adventure, and now we're done with that adventure. And about half of all patent applications result in an abandonment. They're not easy to get, right? And the third option is to appeal, and that's rarely the right option, but it is the option sometimes. Now, has anybody else seen your patent, your idea?
There have been a few people.
Okay, and did you have them sign a non-disclosure agreement?
I did not.
Okay, that's bad voodoo, right? So if you come and do business with our office, we give you a non-disclosure agreement, and you have everybody sign that. Even friends who mean well will sometimes slip up and talk to their sister or whatever it is, and so you want to not do that. You want to keep your invention a secret until you file the patent. People will sometimes think, well, I can file a provisional patent myself. Very rarely do those work. And what that means, and it's much cheaper. It's less than $100 to file a provisional patent. But the disclosure, the specification, and the drawings have to have all of the information that you're going to have when you file your non-provisional less than a year later, or you can't depend upon that priority. So you have to file that up front. Now, there's also the idea of, we've been talking about an apparatus. Sometimes an invention like yours has a very unique appearance. And so we would talk about a design patent as well. And a design patent just protects the appearance of the object. It's much cheaper. It's often easier to get. Obviously, it doesn't protect a different appearing knife that has the same functionality. It doesn't protect functionality.
Okay.
So I've kind of blown through that. Do you have any questions of me offhand?
No, I think you answered it. I mean, I was wanting to know how to protect the intellectual property before the patent, and what
Yeah.
are my features even worth trying to?
Yeah, what we
To
do is
patents.
we would do a patent search. Patent search in our office right now usually runs about $1,500, $1,500. You can have an online organization do it, but they won't really tell you what you want. What you're looking for is a patent attorney to say, I think this will make it, I don't think this will make it, or I think this will make it more difficult than other things. So you want a patent search. You also want to know that you're not infringing somebody else's patent. Even if you decide not to get a patent, you're just going to sell it. Are you infringing somebody else's patent? So that's a freedom to operate opinion. And sometimes that's harder to do than the patent opinion because you're trying to prove a negative. Is there somebody else out there that already has a patent? And if somebody filed their patent application 3 months ago, I can't even see it. It's probably not even public yet. So it's an iffy deal. But you want to do that before you go down that road because you're going to spend a lot of time and effort on something. You don't want to find out that you're building a business for somebody else, and you don't want to find out that you're infringing. And you don't want to find out, well, there's an obvious patent that was already in my way. Why did I bother handing this guy thousands of dollars and spend years of my life when it's an obvious no? Or is there a way to get around that so that you can do what you want with just a tweak here and there? So,
Okay.
non-disclosure agreements, and people will pull things off the web and say, I've got a non-disclosure agreement. Non-disclosure agreements are not should be designed for a particular purpose. You can't just pull something off the web. This may not work for what you need. And obviously, the non-disclosure agreement between Samsung and Apple is different than the non-disclosure agreement that's between you and the guy down the street that's doing some welding for you on a knife. So these things have to make sense for what their application is. I think that wraps it up for today. So, Chuck, I very much appreciate you coming by. I hope if we can help you further, please let us know. And thank you for joining us today. I want to say thanks to Al for joining us earlier. And if you have any questions about patents, we are downtown Arlington, but you can call us from anywhere in the world, and I mean that literally, because we do business for everybody. You don't have to be location specific on patents. So, thanks for joining us. We'll see you next time.
Well, that's a wrap, folks, and we want to thank you for listening to the White Hat Law Show here with Warren Nord. To find out more about Warren, check him out at nordlaw.com. See you next time.